Hello, hello, hello. How are we, people? How are we, beautiful people? Hope you're all well on this fine morning. Um, yes, we are here. Court is in session, so do not worry. We are just a little bit behind, which means we can zoom it, which is on purpose. They've literally just started. They just called up the first witness of the day, which is a doctor. They did resume this morning, and we couldn't hear it. They did meet up about various stuff, but we didn't see for 20 minutes. So I'm not sure what's going on with that. But anyway, here we go. Crystal, good morning to you, my darling. Always praying for you, Crystal. Robert G, how are you, my darling? Hope you're well. Sharon, stranger, danger. How are you, my darling? I know you're there with Recovery Addict, but thank you for popping in, my darling. Kelly, hello. How are you, my darling? Nice to see you. We're in the halfway through the week. Hump day today. There you go, Kel. Daffy Dill, how are you, my darling? How are you? Hope you're well, my darling. Um, Chloe Danielle, how are you, Danielle? Hope you're well as well. Lovely to see you. Viv, happy New Year to you, Viv. Not seen you for a while. There's a lovely picture. Happy days. How are you, my darling? Hope you're well. Hit the like, please hit the like. Yes. Grace, how are you, my darling? Hope you're well. Love the Quinlan name, as always. The Irish heritage on that. How are you, my darling? Hope you're well. There you go. So, what I did say, we're going to start at 9. So, we're going to stay a little bit on purpose. Hey, Christine, how are you doing, my darling? So, for those that don't know, this trial has started, but we're going to start it 15 minutes later. It just affords us the opportunity to skip some stuff and also gives more people an opportunity to come and not everyone could be here or right on time. So, but yeah, I hope everyone is well, as I say. So this trial's finished today. This this trial is donezo today. So it'll be intriguing to see. Obviously, if this is a Florida trial, so there's only 6 jurors. So they got 2 alternates, 6 jurors, 2 alternates. So yeah, it should be quite a quick verdict. From what they were saying yesterday, it'll be done by early afternoon. So I don't know. We'll see. It's a little bit of a strange case because because they still got to do what did they say? They said something yesterday. They're gonna question some of the experts, even though they're not testifying. So I don't really know what's going on, but it doesn't matter. It doesn't matter. So we got another trial. We will start either today or tomorrow. From West Virginia. I think it's West Virginia. It's WV. West Virginia, Mountain Mama. That's where Rebecca's from. It's the husband that poisoned um, by his wife, allegedly. And it's WVA. What's WVA? I don't know what WVA is. What is WVA? I thought it was West Virginia, but it's not. West, West. I'm sure chat will tell me. Her name is Natalie Cochran. She is in prison already for, I believe, 11 years for fraud. But yeah, she's accused of killing her husband. So we're either going to start that today or tomorrow, day 1. So I'm not sure. Depending on how this trial goes, we'll see. Yeah, other than that, I hope you're all well. Now, this is an interesting case. I was thinking about this case last night, right? Covering that one. Happy days. There you go. Christine's covering it as well, so you can watch your Christine if you want to, or as I say, we'll be zooming it through here as well. We will be covering it once this trial is done. Once the jury get, so it probably will be today, I imagine. I'm not going to watch stream the proffer and stuff like that. It's pointless. So, um, yeah, I was thinking about this case. Those who watched it yesterday, what an unusual trial this is. Um, I, woof. This is an unusual trial. I don't know. So it'll be very interesting to see what happens. What the jury. I can easily see a jury say not guilty because they don't know everything. So I don't know. I don't know. Hello, Marsha. How are you, my darling? Nice to see you. So yeah, we'll just have to see, people. We'll just have to see. Um, no one knows WVA, so I'll Google WVA because I don't know where WVA is. WVA in America. Oh, it's West Virginia. It is West Virginia. Oh fuck, I was right then. Why is it WVA? Why the A? I don't get why they put the A in though. Hmm. What's WV then? Is WV something else then? No, it's West Virginia. Hello, Young. Hello, happy New Year to you, Young. Hope you're well as always. Did anyone know one of the jurors on yesterday's stream? Yes, the cameraman did get a row off the judge, so for not showing them anymore. So the judge was aware of it, and there were screenshots of it and stuff like that sent to the judge. But cameraman was reprimanded, and he was all good. It was all fine in the end. Never ideal when they are shown, but what can you do? What can you do with a drunken sailor, as they say? Right. Right, we've got 9 more minutes. I did promise everyone I wasn't going to start until 9 o'clock Eastern, so patience is a virtue, everybody. Patience is a virtue. I do wonder, I'll do a poll. Do a poll here. How would you vote if you jury about death? I know some people are going to say guilty. Oh no, it's the wrong one. Think about it. How you would vote here, because I think we're obviously very biased now with our views. I'm just hopefully everyone's going to think like a Jew or There you go. That's the poll up then. Hello, Hippie Chick. Hello, my darling. Again, Hippie Chick, thank you so much for the gear yesterday. I'm chuffed to bits with it. You see my cold hat behind me there? Oop, cold hat is there. Love it. I've not worn the hoodie yet, but I'm looking forward to wearing that now when I'm out and about. Hello, Patty. How are you, Patty? You couldn't hear it, Daffodil. What's wrong with you? What is this something to do with your volume or something? Ba-da-ba-ba. So, I'm excited, Patty. I'm excited. I am very, very excited to get to meet everyone, Patty. I'm genuinely excited. I can't wait. It's gonna be here. I was looking yesterday. 11 weeks until Karen's trial. 11 weeks. So it'll be with us before we know it. Talking about small people. Small. Hey, Erin Hack. Ole, 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 ole. We'll give it 5 more minutes and then we'll start it. They are there, as I say. We're going to be about 15 minutes behind. They're going to have the doctor on. I think this is the last witness for the state, and then the defense, I believe, got one witness. I do not believe that she is. Well, they said one witness, so I believe it's not going to be her. I don't believe she's going to be testifying. So we'll see. We'll see on that one what happens. But yeah, I would just want to make sure that everyone gets in, because a lot of people are on the way to work. Sarah P's on the way to work, driving like a motherfucker at the minute. So that's the reason for the delay. If anyone's here going, why the fuck's he not playing it? Because I want to make sure people are here. I said I'll play it at 9, so I'll play it at 9. We've only got 5 more minutes. We got loads of times. Loads of time. But yeah, Patty, I got to do an itinerary, Patty. I got to do a slight itinerary. Just because people are asking me where I'm going to be on certain days and stuff like that. So I will do an itinerary. That's all good, Viv. It's all good. It's a bit late with you. I wouldn't be staying up if I were you. That's for sure. You see, here she is, lovely Sarah P, driving with the foot down. I'll be there ASAP. Oh, and Aaron Hack's driving the yellow bus. Sarah P is in the car. Patty's in the car. There you go. Everyone's got me in the car. Eyes on the road. Beep beep. Small bus coming through. Aaron Hack coming through. Beep beep. Right. Thank you, Daffodil. There you go. Right. So, as a reminder, we will also be covering Natalie Cochran, which I think we'll be starting today, this afternoon, because it looks like this trial will be with the jury by lunchtime. And if that's the case, then we'll cover it. Here she is. I was waiting for somebody. I saw Josie. This is 2 from 2 now. Josie's been here before everyone else. I could pin it now. Pin the message. If you see this message, she's brought it every time. Welcome, everyone. Please consider donation to help the channel. Always appreciated. Never required. Buy me coffee, PayPal. There you go. There you go. Thank you, Josie. Hey, how do you make out with the doctors? Do you get more answers for? No, yeah, I got. We're just waiting now. We're just waiting. I'm a lot happy after speaking to the doctor. So we're just gonna wait and see. I'm on the various vitamins and stuff now, and some tablets and stuff. So just waiting to see whether I need got some more blood tests on Monday. So we'll see. But no, I don't know anymore. It's frustrating, but there you go. I fell out of my chair today. I fell out of the sofa. I was sitting on the edge. I fell asleep, and I went head first on the floor. Luckily, my hands went down. I don't know how, but that's the first time I've fallen out of the chair. Just head first, just literally by sleeping. Good morning, party people. Good morning, party people. It's like 10 to 6 in the morning in Arizona. She's perving. She loves a good perv. Right. We'll give it a 1 more minute and then we'll start the party with the trial. I know some people are still driving, but I want to get it started so that we can. I'll say the benefit of doing this is we can skip the break then, which I like. We just go straight through. You just got to bear with me talking for 15 minutes. Hey, Robin G, riding through the Glen. How are you, my darling? Robin G, riding through the Glen. Okay, that's fine. All right. I think I'll set it up now so we can go. The judge just asked the jury if they knew anything about this case, and they all been spoken to anyone about the case, and they all said no. And the first witness is about to come up, so let me get myself up there. And then I'll set it.
Okay, we're going to be in our final day today. So
you see that final day today. So it's a great. This is the kind of trial I love. Day and a half done. Thank you, sir.
Close attention, and we're going to begin. State, call your first.
I was thinking last night, though. What's? Oh, you see, I don't. I'm surprised with the poll. 78% of you say guilty. I'm very surprised with that. I'm very surprised. But right, let's go.
For the day.
Yes, Your Honor. The state calls Dr. Vera Volnick. And just voting.
Please, absolutely.
Step this way.
Here we go.
Yeah,
And if you could please speak up and state your name for the record, doctor, please. State your name.
my name is Vera Volnikh. It's Volnikh.
And how are you employed, ma'am?
I employ as associate medical examiner at the District 10 Medical Examiner Office.
And how long have you been a medical examiner?
20 years.
Could you give the jury a brief idea of your educational background?
I graduated from medical school in Havana, Cuba. I completed my postgraduate training in pathology at the University of Puerto Rico. And after that, I completed my forensic pathology training at the University of South Florida. And after that, I was employed at our current office here in the District 10.
Are you a licensed physician in the state of Florida?
Yes.
For how long?
21, 22.
And you said you're a medical examiner. What are your duties as a medical examiner?
The main duty of medical examiner to determine the cause and manner of death, or how is the person died and why is the person died.
Approximately, and are autopsies a regular part of what you do?
We perform about 300 to maybe 350 autopsy per year, every year, depends.
So how
Sometimes
many-
less, sometimes more.
So approximately how many autopsies do you believe you've performed?
In 20 years,
Yes, ma'am.
oof, a lot.
Fair enough, ma'am. I think you've given us idea of the numbers that we're dealing with, unfortunately. In your personal experience as a medical examiner, have you performed any autopsies on infants?
Yes.
Let me ask you this, Doctor, you mentioned some practices. What is forensic pathology?
Again, the main goal of forensic pathologist or medical examiner to determine the cause and manner of death, or how is the person died and why is the person died.
And have you ever testified as an expert before, Doctor?
Yes,
And how many times?
many.
Many times. Have you testified as an expert in your area in Polk County previously?
Polk County, Hardy County, and Highlands County, which is our District 10.
Your Honor, at this time, the state would tender the expert as far as qualifications are concerned.
Defense? No objection. All right, doctor, you are considered an expert in this court files and for the jury. Thank you very much.
Doctor, I would like to now direct your attention to November 2nd of 2022. On that date, were you asked to perform an autopsy on a baby by the name of Uriel Schock?
Well, I was not asked. Once somebody died in our jurisdiction, we get a call, depending where the body is. Hospital, the scene, we will get the call to our office. Somebody present out the case. We determine that the case, medical examiner case. Once we determine it's our case, we will dispatch our transport to the place where the body is located, and we will bring the body to our office. Once the body arrives at our office, whoever on that day on duty will perform the autopsy. So we are obligated to do that.
Pardon my poor choice of words. I guess I should have said, were you obligated to perform the autopsy? So you did perform an autopsy on Uriel Schock?
Yes, it's of course it depends case by case. Sometimes we don't perform autopsy if we have enough information. Let's say somebody been in the hospital, we get preview of medical record, medical history, and we may determine the cause of death, including the manner of death. But in the infant or children's, we almost always perform the autopsy to see what happened.
Why is that, doctor?
Well, children cannot talk, infants cannot talk. Sometimes we have to exclude all the possible causes of death, like trauma, intoxication, any diseases that the children may have, which was not diagnosed. So we have to look at that to determine the cause of death.
And in this situation, how do you normally start out conducting that process?
Well, in this particular case, we get the call from the hospital, and they say there was a child that left in the car for several hours. So we say, okay, this looks suspicious, so we will bring the body to our office to examine. Again, we dispatch our transport. The transport will place the body in the body bag as is, seal the body bag, and that bag will be transported to our office. Once the body arrives at our office, we will open the body bag. We will take series of photographs of the body as is in the body bag, with any medical equipment attached or any clothing that on the deceased. After that, we will remove the body out of the body bag. We will remove all the medical devices, clothing. We clean the body, and we'll take another series of photographs of the body, front, back, from all the angles. The reason we do that is to show presence or absence of any injury on the body. That's what we do. And
If I may, Doctor, in this instance, since we're talking about the external examination, did you notice any of that, any evidence of any trauma or anything like that?
when we do the photographs, it's kind of part of examination, but we just do for preservation purposes, we do all these photographs. And like we say, then we decided, okay, we're going to do autopsy. Autopsy has two parts: external examination, which include looking at the body, see if there is any injury on the body, visual injury. Sometimes you can have visual injury from externally, but or you have no injury externally, but you may have something internally. So if we find something, we document it again with the photographs and with the description. So once we perform the external examination, we also, before we open the body for internal examination, we also do the x-rays on the body, especially in the children's. We look for any acute or older injury of the bone, of the extremities, or the ribs. So we look if there is any previous injury that have been healed. And we didn't find any on this case, neither we have any external injuries on the baby.
So you did not note any external injuries?
She did not have any external injuries.
And what is after you finish the external, you also mentioned before you go internal examination. Is that what you would have done next in this case?
Yes, then once we do the external examination, we proceed with the internal examination. That means we will open the cranial cavity, we look at the brain, we open the chest cavity, we look at the organ, heart and lungs. Then we look at the abdominal cavity, if there is any infection, any trauma, anything that will explain why this child died. And we also collect the body fluid of the body. We take eye fluid, blood, we take urine, stomach content if it's available. And we send that to toxicology labs, so we exclude or confirm any substances that may contribute to the death of this child.
And from your internal examination, did Uriel suffer from any infections or substances or anything like that caused her death?
No, no. Also, like there's some substances can elevate your core body temperature, like amphetamine or cocaine. So we always look for those two, and obviously we didn't find anything. We find no evidence of trauma. We have no evidence of any disease. So there was nothing to explain her death, except that she was in the hot car. And that's...
So, Doctor, let me put it this way. You reviewed and you did your examination. Did you come to any conclusions about what the cause of her death was?
Yes.
And what was that?
We say that she died of hyperthermia.
And what is hyperthermia, Doctor?
It's elevated body temperature due to either drugs diseases or environment that contributed. In this case, that she was in the car, left for a couple of hours. We came to this diagnosis by excluding all the other causes that can be like trauma, infection, intoxication. So we say that she died of hyperthermia.
And hyperthermia, is that something that's instantaneous, doctor?
No, this is not instant death. She will die slowly. If you leave somebody in the car, in the enclosed car, about 10 minutes after, the temperature in the car probably rise about 19 degrees more than outside. So if you have outside 90 degrees, in the car it will be probably 110 degrees. If you leave for 40 minutes, the temperature inside the car rises up like by 40 degrees more. So it's 130 degrees. So now when your body temperature is, you are there, so your body start fighting this heat. So what the body does, the blood vessel dilate. She will try to sweat, because when you sweat, the fluid evaporate and it's cool the body. But if she's long time in the car, then she start, losing that fluid. Her blood pressure going to drop. If your blood pressure drop enough that it's not going to deliver proper oxygen to your brain, you start suffering. With your neurons start dying, so the brain starts swelling. You will become unconscious, not dead yet, but unconscious. You may have seizures. Also, if your brain don't have oxygen, enough oxygen for about 10 minutes, you will die. You become brain dead, and that's irreversible. If she rescued before she's brain dead, she may or may not recover, because not only the brain suffer, the other organs also suffer. You can have liver failure, heart failure, kidney failures because of the heat, and because again there's no enough blood, oxygen going to the organ to sustain the life of those organs. But no, this is not instant death.
So, doctor, based on your professional opinion, would Uriel have died had she not been left in that hot car?
There is no reason why she will die. She was completely normal, well-developed, well-nourished child.
Thank you, doctor. I have no further questions. Oh, I do have one question. I take that back, doctor.
I'm approaching you with the pre-marked State's Exhibit number 64.
Do you recognize that, doctor?
I do.
And is that Uriel Schock who you performed the autopsy on?
Yes, that's we call it this picture, identification picture. So we just take the face for identification purposes.
Your Honor, this time the state would seek to enter into evidence stated 64.
Defendant?
No objection.
Okay, let me have it.
And Your Honor, with that, I have no further questions.
Okay. Submitted without objection. All right, defense, any questions? Direct across?
Yes, Your Honor. Please be calm. Just very briefly. Doctor, you remember Detective Samendel, also known as Detective Fletcher?
No,
You remember speaking with her?
no,
You don't remember telling her that the death of this child was sudden and quickly?
no, I will not say that. This is not sudden death. The sudden death is something that
Ma'am, did you say that? That's my question.
you
To
asked
her?
me if I remember. I do not.
Okay.
And
And did
It's
you say
not
because
instant
of the
death.
contents of
Hang on,
the,
hang on a second. We need to ask a question, let her give an answer.
did you didn't tell her because you looked at the contents of the stomach and you could tell that the death was quickly?
quickly and instant, it's not the same. The quick mean less than an hour after person eat, and if it has something in the stomach, it will depend on what the child eat. If it is formula, it could be there for 2 hours. If it's breast milk, it can be only 30 minutes, maybe at them you don't have anything in the stomach. Again, it's not instant. It's quick, but not instant.
Say quick, but not instant.
It could be an hour. That's quick too.
Thank you, ma'am.
State,
Yes, Your Honor, briefly.
Doctor, I want to just focus on the questions that were just asked to you. You said that based on the stomach contents and how quickly they're gone. Obviously, if you had information about when Uriel last ate, it would be more useful and more useful to your opinion on as far as what quickly is. Is that safe to say?
Well, again, we know that she has something in the stomach. So whatever she eat, which I don't know what time she eat, she still have some food in her stomach, partially digested food. So that means that she don't digest completely. Like I say, if she eat formula, it stay almost for 3 hours. So it's maybe less than 3 hours that she died since she eat last time. Again, I don't know what time she eat, but it's not instant death.
Okay. And so that just so it's clear, when you say quickly, you're not talking 5, 10, 15 minutes.
Again, quickly doesn't mean instant. It's not instant death. She was, alive to produce all that sweat that this child have, because when we receive these kids cases, we have also information from, let's say, EMS, law enforcement. So we read all the report. And we know that the child was, her clothes was completely soaked of sweat. So that means that child was alive for some time to produce that amount of sweat. So again, quickly could be an hour. If the temperature rise very fast, very high, she cannot, even the adult cannot sometimes overcome the hyperthermia. In the children, it's even worse. They get very hot very quickly. So again, they try to sweat, but because they cannot overcome that insult, so they became unconscious first, and then they die after the brain dies.
So is it fair to say that when you use the term quickly,
Leading question, Your Honor.
overruled.
so when you use the word quickly, it's more of a term of art compared to hours, compared to days? Would that be safe to say?
Correct.
All right.
No further questions.
Okay. May this witness be excused?
Yes, Your Honor.
Defense, do you agree? All right. Thank you, Doctor. Have a nice day. You're free to do your business.
Thank you.
All right, state call the next witness.
Your Honor, the statement of the witnesses at this time, I believe all the evidence has been entered. I checked the clerk. This case will rest.
All right, state rest. Let's take a stretch break, members of the jury.
All rise.
We can get you back here in a few minutes.
Sorry for ask for a judgment of acquittal on count one.
JOA, okay? State brief argument.
Your Honor, the state has put on a prima facie case. It's given enough to make this an issue for the jury to determine whether or not the acts of Tracey Nix were simple negligence or culpable negligence based upon the surrounding circumstances. Culpable negligence cannot be determined without a jury looking at those circumstances that surrounded the negligence and determining if they're wanton and reckless. And I believe the state has put out enough evidence for the jury to make that decision.
All right, based upon the state's presenting a prima facie case, this case goes to the jury. JOA is denied.
Your Honor, for the record, what I'd like to make an argument, and I'd also like to present just a copy of the order from the Florida's Second Circuit Court. It's not binding, obviously, but it is persuasive.
Is this for count 2?
This is for count one,
Okay.
culpable negligence.
All right, go ahead and, all right. Go ahead.
Your Honor, the definition of culpable negligence requires someone consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The evidence presented yesterday and today by the state in its case does not demonstrate any conscious action by Ms. Nix. In fact, all of the conscious actions taken by Ms. Nix that day were for the benefit of her family. She was doing a favor for her daughter. If you watched her in the video, you saw her put the child in the car seat. What would have been reckless would for her not to put the child in the car seat, put her in the backseat of the car and just drove around like that. All of her conscious actions, and you heard from witness testimony from the three friends that she had lunch with, that she was behaving normally, that she was a loving, caring, doting grandmother, that she was happy, that the child was happy. All of that demonstrates that she was acting in an appropriate manner. The state didn't show anything that was an aggravating factor. There was no evidence of substance abuse. There was no evidence of prior abuse. There wasn't any evidence presented of her repeatedly leaving the child in the car before. So, Your Honor, we argue that there's no evidence of her doing a conscious act or doing a reckless act that would put the child in danger. And without one of those acts, without some aggravating factor, the state cannot reach the level of culpable negligence.
Okay, is this case appeal still pending?
This case here is actually, this case was an order granting a motion to dismiss. And I don't believe the state tried to appeal the motion to dismiss. I put this into the record specifically because it does probably the best job I have seen analyzing all of the case law around culpable negligence, particularly when it comes to a child being left in the car. And one of the things that I noticed, and I thought it was strikingly similar to this case, the court ultimately concluded that the act there was a single, unaggravated, and inadvertent act of negligence despite the tragic consequence. The admitted facts are insufficient to support the offense of manslaughter by culpable negligence. And essentially in this case, it was a mother who had taken her, she had two children, each went to separate schools. She took one child to school and she forgot to take the other one and drop her off at daycare. She went to work and she went about her day. She even received a call about the child from her partner, I guess it was her former partner, and they discussed the child. And it wasn't until she actually went out to lunch to go leave that she realized that the child was in the car, and the child unfortunately had passed away. And the court in that case found that essentially the act of negligence of leaving a child in a car is one of simple negligence. And the court also found that because of the way that memory works, that the amount of time isn't really an issue. When you forget something, you forget something. There's no way you can control when you're going to remember. Now, maybe there's something that cues you to remember that, but people forget things all the time. I mean, I might drive down to my driveway with the intent to go get my garbage can, and then drive all the way to work and realize I didn't do it. But then I might not realize that until I get home and I see it in the driveway.
Okay, thank you. Anything further from the state?
Your Honor, I believe this case, first off, this is a circuit court case, and it is a motion to dismiss, and it's a trial case. I would say this case is distinguishable because we have Tracey Nix was the sole caretaker of a sole child that she spent all day with, or all lunch with. And the facts as far as what she did and providing all that care and all that time with her at Lethal Brady's and getting in that vehicle, going home, and just thinking about other things other than that child, Your Honor, I believe it's distinguishable from this matter because in this case that the defense has cited, once again, this circuit court case deals with a person taking care of two children and being distracted by one and the other. She had no other distractions. Her only responsibility was to this child. Only responsibility. And she provided that and then stopped. And I think that's different here, along with the other factors that are present there. It's not just those two things, but I'm just pointing out that which makes it distinguishable from the case that the defense is trying to present to the court. And once again, this is a motion to dismiss, not a trial case in which the question was whether or not there's a prima facie case.
All right, based upon the evidence that I've seen, the evidence, the 64, 65 items, and the testimony, the state's presented a prima facie case, JOA is denied. Same rule. Second, the argument, if any, from the defense.
Your Honor, on count two, we will reserve our objection to the jury instruction on count two. We're not making an argument for a motion for judgment of acquittal on count two at this time.
All right, so there's no judgment of acquittal, so there's no reason for me to rule on it. All right, defense, are you ready to present your case?
Yes, Your Honor.
All right, Mr. Jury.
Sure.
Present your. Mr. Nix.
May it please the court.
Yes, sir, go ahead, Mr. President.
State your name for the jury, please.
None, nay, Nix.
And Mr. Nix, you're the father of Kayla Nix.
Yes, sir.
You're the father of Rebecca Tucker,
Yes.
and you're the husband of Mrs. Nix.
Yes, sir.
Okay. All right. And obviously you remember Uri.
Yes, sir.
Okay. How often would you and or Tracey keep Uri?
Depending on the week, anywhere from 2 to 5 days.
Okay. Can you give we'll say a normal routine on how that would occur, the pickup and the delivery?
Most often would be me going to their office to pick up the child. And then I would bring her back to the house. And that's where usually Tracey would pick up.
Would pick up from there?
Yes.
Okay. And when you would drive to pick up Uri, what vehicle would you drive normally?
Normally was my truck,
Normally.
pickup truck. Yes.
Did you ever drive the red Lexus?
Yes, sir.
Okay. And in the evening, how would she get, we'll say, redelivered to her parents?
Normally was her father, Drew, would normally come by after work.
Okay. And on occasion, did you drive the Lexus
Yes.
to either pick up or redeliver
Pick up.
the child? Okay. And when you had the mirror adjusted to the back, were you able to see the car seat from the back seat, driver's side?
No, sir, not for me.
Okay. Now you're a little taller than Tracey.
Yes, sir.
Okay. Can you tell us, would Tracey be able to, from her viewpoint, from what you saw in the Lexus?
Judge, it's speculation.
Sustained.
If you're looking out the back window from the rear view mirror, is your view going to be the same as hers if it's properly adjusted?
Yes.
Okay. And did you ever, we'll say, have a situation where you got into the car and it was adjusted for Tracey?
Yes.
And y'all have some issues about that sometime?
Some minor discussion.
Okay. All right. Thank you.
State, any cross?
Briefly, Your Honor.
Mr. Nix, I just have a few questions for you. As far as the vehicle, the Lexus, it has windows, right?
Yes.
You can see through those windows?
Yes.
No further questions.
All right, redirect.
Yes. On the day in question, Could you see through those windows?
Yes,
And on the day in question, before Uri was found in the back seat, were you near that vehicle on your lawnmower?
yes.
And could you look into the vehicle?
Not from where I was seated on the lawnmower
Okay, and why was that?
because I was located a small distance from the car at approximately the same height as the driver.
Okay, and you could not see the child?
No,
Okay, thank you.
All right, he may be excused. Mr. Fletcher, may he be excused?
Yes, Your Honor.
Okay.
Yes, sir.
Thank you, Mr. Nix. State, defense, call your second witness.
It's rest, Your Honor.
Okay, let's,
Just gone to sidebar. Sorry, my camera was playing up. But they've gone to sidebar now. Bear with me once I get it caught up again. But you're not missing anything, so it's fine. I love you, baby. And if it's quite alright. So why my camera's playing up, I don't know. Dee 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 dee. Those are the parents. I think they're looking at the mother, grandmother.
it may be around about 25 minutes. So please take your time. Got attendance and business. Members of the jury, we're going to take a brief recess. I've got attendance and business with the lawyers. So it may be around about 25 minutes. So please take your time to go to your cars, do what you need to do, but please be back in about 20 minutes.
All rise.
With a further caveat that verdict in this case would be against the weight of the evidence.
All right. With that, it's still denied unless the state wants me to go over any other arguments.
No, Your Honor, state would rely on figures.
Okay, let's bring Ms. Nix up here. Let's get her sworn in. And I'd like her on the stand, please. You want to stand? You want to stand? Get Ms. Nix sworn in, please.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, Ms. Nix, have a seat. All right, so Ms. Nix, state your name for the record.
Tracey Ann Howard Nix.
Okay, this is a criminal trial brought by the state of Florida versus Tracey Nix, CF 22-289 Hardy County. You're the defendant in this action, and you've chosen not to testify. Is that correct?
Yes,
Is that of your own free will and volition?
it's on my lawyer's judgment.
Okay, so you're relying upon your lawyer's judgment not to testify.
Correct.
And you understand you have the independent right to override that judgment and to testify. Yes or no?
Yes,
So you understand that this is your ship and you're the captain of it. And you can testify if you so choose to, but you're relying upon the advice of your attorney. You're saying not to testify.
yes,
But it's your decision to make individually.
yes,
And you're still choosing not to testify.
yes.
Based on the hesitation, I'd like to take a short conference with Mrs. Nix.
Okay, let's have a brief conference with Mrs. Nix.
Can we go outside?
You can go outside, yeah.
Okay. Wow. She might be testifying then. Because she hesitated so much that the lawyer wants to re-ask her, are you going to testify? Well, this is why we do this. Zoom, zoom, zoom. Everybody zoom, 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 zoom. Zoom, zoom, zoom. Hello, Amy. Hello, everybody. Hello, Tracy. Zoom, zoom, zoom. Here we go. Zoom, 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 zoom. We're zooming. Here we go.
Sufficient time to consult with your client?
Yes, sir.
Is it still her intent not to testify?
That's correct, John.
All right, so Ms. Nix, you had a conference with your attorney outside, and it's your intent not to testify.
That is correct.
Has anyone forced you not to testify?
No, sir.
Has anyone promised you anything to get you not to testify?
No, sir.
You understand you have the right to take the stand to testify.
I do.
You understand that decision is totally up to you to testify or not, since it's your decision.
I do understand.
And whether you testify or not, that's in your sole mind, and it's not based upon what your lawyers are telling you or not telling you. That's your personal decision.
That's correct.
And you understand lawyers give advice. If you choose to testify, then the state will cross-examine, and you will have your waived your right to remain silent and will testify on your own behalf, just as any other witness.
Yes, sir.
All right, with that being said, I find she knowingly and intelligently has waived her right to testify and will be sitting at council table. And go ahead and seat. Let's take our 20-plus minute break. State, when you get everything together, please make sure we have everything with sufficient copies and things that we need to. So we're going to go right into, let me double check. I'm going to give a closing argument. Y'all do your closings, and then I'll go right into the final instructions and things.
Yes, Your Honor, and just to make sure the state understands, you would like obviously copies of the instructions for Your Honor, the 6 for the jury.
Correct. 6 for the jury.
The redacted information to go back with the jury, and 1 for you to read.
Correct. And then the verdict form, you'll have a copy of the verdict form and the instructions, but then I need a separate copy to put down for the clerk. Anything on that clerk's table, defense and plaintiff and state need to make sure y'all have gone through it, because it's going back. I don't want to hear, oh my gosh, we forgot the word insurance or something like that, like I've heard in the past. So what's on that table in front of that clerk is going back to that.
So here we go then. We were 10 minutes behind, so it's about another 10 minutes before closing arguments. You see, this is the beauty of zoom in. We're zoom in. So it's interesting. I thought that was a shit defense, by the way. Right, what am I going to say to you? What was I going to say to you, people? You lovely, lovely people. I forgot what I was going to say. Fuck. So yeah, zoom. I've zoomed it. We are live. We are live right now, Josie. We are live. We're about 10 minutes behind. So they just took a 20-minute break. We were 10 minutes behind, which means this is about 10 minutes left before they start closing arguments. Both sides get 15 minutes each for closing arguments. And then obviously jury instructions. They would talk about Dorber hearing. I'm not going to cover that because I literally have zero interest in that. I don't know why they do that. Hi Mark, how are you doing, sir? Nice to see you. So once the jury get the case, my plan is then to start another trial on another stream. So that's what I plan on doing. That will be the wife accused of murdering and poisoning her husband, called Natalie Cochran. And what I'll do is, once there's a verdict in this one, which will be a verdict very quickly, I think, I will play that on the other stream. So that's the plan. And yeah. I didn't really want to do all this streaming, but Sarah P and Josie and Erin Hack and everyone's on my back when they're whipping me into shape, so I've got no choice but to stream. So yeah, I just think it's an interesting case. That's an interesting case as well, Natalie Cochran. So whilst we can play it, we will. I think that's the plan on it. So yeah, I've not set up the other stream yet because I don't know what time it's going to be at, but I might take like a little bit of a break in between, like half an hour or something. So we'll see. Yeah, I don't think I'll be able to, Christine, my darling. But happy birthday to Christine. So yeah, right. Let's see the poll. So I was looking at this, right? So poll is 29 votes, 72% say guilty, 20% say not guilty. I think she's going to be found guilty. I don't think it's just as easy as saying she's guilty, because what you got to remember is the jury have no background on anything. So it's going to be very interesting, I think, of how they view this. I think they will come together and vote guilty in the end, but it depends on the closing arguments a lot, I think. So I think if it wasn't the fact that it was a car, like, as cruel as this sounds, if it had been the other grandson that died in the pond, I think the jury might have had a harder time finding guilty. But because you left the child in the car seat, and there's no medical reasons, if there'd been medical reasons presented, then fair enough. But there's been nothing. So I think she's going to be found guilty for that. I think it's easier to say not be sure, because obviously toddlers they disappear, they violation stuff. So I think that's more plausible. The fact you left her in the car, that's not as plausible in my opinion. So hello, Shari D. So I don't know. So I think they will find her guilty because of that. On this anyway, I think that they will find her guilty because of the car. If it was the other way round and there was a pond drowning, I don't think they would have found her guilty as easily anyway. So, but this one, I think, I don't think you got a, like, if there was any medical issues or any any issues like that, then fair enough. But there's been none presented, so I'm afraid it has to be a guilty. I think anyway. So yeah. So it's a 70-30 so far, 30 votes. So that's 20 say guilty, 10 say not guilty. Yeah, these things do happen, and it's very unfortunate. The pond incident, unfortunately, is something that happens way too often because toddlers do tend to just drift off. And as much as you want to have eyes in the back of your head, sometimes they just go without you knowing it, and it might only take you 30 seconds, but in 30 seconds you panic, where the fuck have they gone? That I can understand a little bit more. This I can't understand. I can't understand this, because you come out your car. What do you do? Come out your car and just walk straight? Like, I don't know. Anyway, that's just my tuppence before we start back. Shari D is in the house with the tits and clams. Ooh. Yeah, it's nice to see Tracey V. I've not seen you for a while, Tracey. Love to see you, my darling. So yeah, just as a precaution, we got 50 minutes. 50 minutes. What do you call it? Closings each, and then jury instructions. Then they're doing Dorbert hearings, which I had no interest in because it has nothing to do with this case. It's a future. I think it's more civil or something. I have no idea, but we will stop it there, and then we will go over to the next stream, which I don't. Should I set it up now? What's it now? If we start at 3 o'clock Eastern, 4-5, they should be done. 5:30. What I might do is start it at 1 o'clock Eastern. So that'll give me hopefully a half-hour break in between. Yeah, that's what we'll do. We'll do the next stream at 1 o'clock, sorry. And then what I'll do is It's directly from here over there, but you might have to wait till 1 o'clock because I don't know what time this stream is finishing. Because then we can zoom through the other trial then. So hang on, let's have a look at the. Let's have a look. They did not start on time. They are about. Oh, they're about 30 minutes into that new trial. So yeah, I like it when a plan comes together, people. Oops, shit. So hopefully, yeah, as I say, looks like they're coming back in now. The family and the observers. Hello, Yaya Trucker. Right, this is. Oh, you covered her again. We never can see the court reporter. We could never see her. The husband testimony did not help her. Nothing has helped her. So it's. I don't know the background, right? Because she's facing 12 to 30 years. So 12 years minimum, 30 years maximum. She's what, 68 now? So basically life in prison essentially for her. I'm surprised they didn't offer a deal of some sorts. Because the daughter is like in distraught, obviously, as you can imagine. She's like she can't win because on one hand she wants justice for her kids, for her kid and kids. On the other hand, it's her mother. As a bus outside. Um, so I wonder if they did offer a plea deal. I don't know. Maybe they did. Maybe they didn't. I don't know. I find it quite tough. Like he's just smart. Fair play to him. Call him over. I think the grandmother doesn't think she's gonna be found guilty. It's like I can't read the grandmother. I don't know what's going on in her head. I really don't. This is a weird, like. I don't think I could face court if I don't even want to think about it. I don't even think about what I would do in her situation. Like, I don't think I'd be in court right now. Jeepers. The grandmother, she's laughing and joking yesterday. I mean, what? Like, yeah, like as I say, right? One grandchild is destroy your family. Two, within a couple of years, and it's like, I don't think I could live with myself. Genuinely. Even if one, I don't think I'd ever want to look after a child ever again. I'd have to be like, no, I just can't. Like, I wouldn't trust myself. I'd be like, no, I can't. You'd be distraught. Here she comes. I don't see how she doesn't get found anything but guilty. Yeah, maybe Sarah. I, in this situation, I don't think it makes. I think they're going to look at it and go, "How do you leave a grandchild in a car?" Full stop. That's the sister and her husband or boyfriend, wherever he is. He's a big unit. He is. So it's interesting. My argument on it is, as I say, Daffodil says that, but if this was the drowning case right now, I'd find her not guilty probably. I just can't get over that you leave a child in a car. That's the bit I can't get over. I even forgetting about the first grandchild. Forget about that for a second. Is leaving a child in the car in that weather, in that temperature. I don't see how he could without what do you call it? I don't even know what I was going to say. Well, yeah, without having any kind of I'm trying to justify it, and there's nothing. There's no medical reasons. There's nothing out there. So there's no excuse. Do you know what I mean? What was so important? Because she's playing the piano and stuff inside. It's like, but has she been tested for dementia? And what's the actual something manslaughter? I don't remember what it's called now. But essentially, basically it's the same as Ashley Benefield. So it's between 12 and 30 years she's facing. So this is Florida. They don't fuck about. That's it. Aggravated. That's the one. Aggravated manslaughter. So it's a minimum of 12 years. I mean, the defense is going to try and say it's not aggravated, but it's like, dude. Was the baby sleeping? I don't know if the baby was sleeping or not. I don't know. I would agree with what Josie says there. Right. The only thing that I would disagree with is on this occasion, this is her second grandchild. You would think that she would wrap this grandchild in tissue. That you would want to know where they were. Like, I would probably put this grandchild in a fucking, what do you call it, harness. Because it'd be like, after what happened to the first grandchild. That's the one, yeah. Dana's got it. Dana's got it. That's the description. Hello, Mary. No, they didn't hear about the other grandchild. No, they didn't hear about that. She was a headmistress teacher, and then she's a principal, and she's a leader in the church. Drowning is awful. You fully are aware you're watching a child in water. Yeah. What was it? She was asleep, wasn't she? When the drowning happened. Because that's what I'm saying. That one I can sort of understand because the kid left the house unsupervised, but I just can't get over the in the car bit. Right, we're back. The judge is back anyway. Hey, Hens, how we doing, my darling? Yeah, 2 grandchildren. First grandchild in her care left her house, snuck out the house. Hello, Lady Di. Nice to see you, my darling. And drowned in a pond near the house. And then this one. That was more of a thing of not an actual harness, more of a. My point was that you would wrap around in cotton wool. That's how you should never forget because of what happened to the first grandchild, more than an actual harness. I wouldn't put the child in an actual harness. This is where I think they are. Dana, the defense trying to say involuntary manslaughter. So I've been to see what the charges are in totality, because we've not heard them yet. So they did it behind closed doors earlier on this morning. So we'll hear if they've added any charges. Maybe they've added a charge, like Dana just said, involuntary manslaughter. I'm not sure. In Florida, they do tend to add in different charges.
312. The verdict form is included thereafter. We, the jury, finds count one, defendant Tracey Nix is guilty of aggravated manslaughter of a child, or the defendant Tracey Nix is guilty of manslaughter or lesser included offense on count one, or Tracey Nix is not guilty. We, the jury, finds count two, defendant Tracey Nix is guilty of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, or the defendant is guilty of leaving a child in a motor vehicle in excess of 15 minutes.
Okay.
Lesser included offense of count one, or defendant Tracey Nix is not guilty. So say we all this blank day of January 2025, four-person print name, single defendant, multiple counts, 312A, 313, submitting case to the jury. 4-1 and 4-2 are reserved for the appropriate times. Defense, you agree with these jury instructions subject to your prior objections?
I'm just looking, double checking before we go. There is something on 3.12. I'm just not certain that I want to discuss.
Take your time. Can you have a separate verdict form, Brian, or do we need to make one? Did you give me a separate verdict form?
Your information that you requested?
Yeah.
Okay.
Let me look at the information, and let me look at the information in separate verdict form. Thank you. I have no problem.
There's your information and a copy to go back to the jury. It has been redacted as far as level of hearing.
Okay, so the information is in the Circuit Court, 10th Judicial Circuit, Hardin County, State versus Tracey Howard Nix, 22 CF 289. Aggravated manslaughter of a child, count one. Brian Haas, State Attorney, bond through his undersigned Assistant State Attorney, charges Tracey Howard Nix on or about November 1, 2022, in the County of Hardin, in the State of Florida, willfully or by culpable negligence did fail or omit to provide Uriel Schock, a child with the care, supervision, and services necessary to maintain the child's physical and mental health, that a prudent person would consider essential for the well-being of the child, and said Tracey Howard Nix was the child's parent, adult household member, or the person responsible for the child's welfare, and as a result of said culpable negligence, Tracey Howard Nix caused the death of Uriel Schock and/or caused great bodily harm, permanent disability, or permanent disfigurement of Uriel Schock, contrary to Florida Statute 782.07, 827.03. Count two. Informant aforesaid under oath, further information makes that Tracey Howard Nix on or about November 1, 2022, in the County of Hardin, in the State of Florida, being a parent, legal guardian, or other person responsible for Uriel Schock, a child younger than 6 years of age, did leave said child unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes, and in doing so caused great bodily harm, permanent disability, or permanent disfigurement to Uriel Schock, contrary to Florida Statute 316.635. There's nothing telling what degree of felonies these are. They appear to be redacted. Do you agree, defense?
Yes, Your Honor.
All right, there you go. And I need that goes back to the jury. Do I have a verdict form?
Yes, Your Honor. I also, there was one provided in the instructions, but
There's one, I'd like a separate one.
I did the separate one for you and the jury.
Hold on. All right, the verdict form is as I read it earlier. Could you please put that clip on that, put it with the information? That'll go back to the jury.
Your Honor, I have reviewed the verdict form and the defense accepts the verdict form. I have reviewed the jury instructions. There was one minor thing, I think it was in 3.12, that I asked the state if they could correct it, if it appears to be an error.
What is it?
Your Honor, in the language, in the language as far as whether or not you can find someone guilty of various lessers. There are certain crimes in which you can be found guilty of multiple lessers, and that language was accidentally included in there. I've deleted it, I've printed it, I have someone from my office bringing it up. It'll be here before you start to read.
Yeah, so basically it's a replace 312 with what you're gonna get.
Exactly.
Okay, so do you want my clerk from Hardy to replace, or do you want to replace?
Whatever I'm assuming it's gonna be brought up here momentarily, and I can do it, or.
All right, clerk, you want to do it, you want the state to replace? All right, state's gonna replace it. Thank you.
Sure.
Your Honor, defense has reviewed the jury instructions other than the previous objections that we made. We find the jury instructions acceptable.
Thank you. Hold that. Second page. State, you gave us 2 front pages on the verdict form. Just give me the back page, please.
Oh,
I'll do it. No problem. Give them back the front page. I'll take a look at that. It's in the package that we're out to give us that. So for the record, state and defense, come on up here. And bailiff, come over here.
Just for clarification, because I saw Les and mentioned here about, I'm waiting for what her doctors have to say. Just for clarification, I'm not streaming that. There could be a Dorber hearing with some medical experts after the judge does his the reading, the jury instructions. The reason is I have no interest in it because it has nothing to do with the trial. So I am going to skip to the other trial. So, I mean, obviously there's other people streaming this. If you want to listen to the Dorber, if it is being streamed, I don't know if it's being streamed. Why are you zooming in on this for? New to him who? I remain confident of this. I will see the goodness. Oh, I don't know what those are. Whoa, some meaning. I'm not sure where they're from though, from the Bible, but they look like Bible verses. Or some of them might be just her thinking. Yeah, yeah, they don't need to be showing this. This is personal to her. Yeah, that Lord is my light and my salvation. When shall I fear? The love is of. Yeah, okay. We don't need to see this. Due to him who. Cheapers. Okay. Right, jeepers. This guy, he's gonna get another row off the judge if he's not careful.
appreciate you.
So the jury hopefully on the way in a bit now. So yeah, just a reminder, closing arguments, jury instructions, and I'm done with this trial. There is a Dorber hearing. You know, there's other streams you can watch that in. I have zero interest in it. I'm only interested to hear what they put in the trial. And then at roughly 1 o'clock Eastern, we will start our new trial, which is currently ongoing. It is the husband who was poisoned by his wife, allegedly. And that is West Virginia versus Natalie Cochran, day 1. Everybody, rock your body. So there are lesser included as well, just so you remember. It's not just the top one, aggravated manslaughter. There's also, I think, general manslaughter, and then the other ones are lessers about the granddaughter being in the car for more than 15 minutes. So it's not slam dunk that she'll be done for the first one. Here we go then. Hello, lady. Good morning to you.
Are you on, kids? Bring them in, please.
All right.
Hi, Karen.
All right, everyone have a seat, please. Members of the jury, we'll have break. Has anybody discussed this?
Hi, Patricia.
Case or heard anything about this case while on the break? Please raise your hand if you've heard it or discussed anything. All right, seeing no hands are raised, we're going to go into closing arguments. Both the state and the defendant have now rested their case. The attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, is prepared?
Yes, Your Honor. Is the court?
Go ahead, Mr. Coleman.
Counsel?
Yes, Your Honor.
She just had her to suffer, and she just boiled to death.
Members of the jury, as we go through our lives, one of the early lessons we get is everybody makes mistakes. Most of the time, we apologize, we accept responsibility, and we move on. Unfortunately, some of us in this room might have learned sometimes sorry is enough for those mistakes. Sometimes those mistakes carry dire consequences, and sometimes those mistakes are crimes. And that's why we're here today. And I would argue to you that is why the legislature of the state of Florida passed the very laws we're here today that the defendant is accused of. So in order to discuss this case, to discuss the facts, what's important first is that we discuss what I believe you're going to be instructed on as far as the law related to this case is. You will receive copies of these, so please, you don't have to write furiously. What I believe the judge is going to tell you is to prove the crime of aggravated manslaughter, the state must prove the following three elements beyond a reasonable doubt. 1, Uriel Schock is dead. 2, the death of Uriel was caused by the culpable negligence of Tracey Nix. 3, Uriel was at the time a child, and Uriel's death was caused by the neglect of Tracey Nix, a caregiver for Uriel. Now, I just want to get out in front of it and just tell you, I believe the crux of this case, what everybody's going to be talking about, what you yourselves are going to be talking about, is number 2. Culpable negligence. What is it? So, but it is my job, it is my burden as a state to prove the crimes. And even though 1 and 3 are not in dispute, we're going to talk about it, get those out of the way, and move on to the crux of the case. So, 1, Uriel Schock is dead. The court instructed you. We've agreed. The parties have agreed. She's dead. That's not an issue. Skip to 3. Uri was at the time a child. Once again, that's not in question. She was 7 months. And her death was caused by the neglect of Tracey Nix, a caregiver for Uriel Schock. Was caused by the neglect. So just from that point, just neglect. She left her in that car. That's not in dispute. What's in dispute is whether or not it's culpable negligence. There's no dispute on whether or not it's neglect. A caregiver, there's no question. As the judge will inform you, a caregiver means a parent, adult household member, or any other person responsible for the child's welfare. She was Uri's grandma. She was the sole caregiver at that time for Uri. Uri was solely dependent on her for care. So I would argue to you, members of the jury, that 1 and 3 are not in dispute. So let's talk about 2. Before we get there, there's this language that we're going to get to in culpable negligence that may be confusing, but it's clarified by what the judge is going to instruct you on what neglect of a child means. It means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to for the well-being of the child. Here's the thing. Neglect may be based on repeated conduct or a single incident. Repeated conduct or a single incident, or omission by that caregiver. They didn't do something. So I want you to keep that in mind, please. So we'll turn to it. The death of Uriel Schock was caused by the culpable negligence of Tracey Nix. Remember, it could be a single incident. I anticipate the judge is going to tell you that aggravated manslaughter, he's going to tell you at first, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence, simple negligence. So it's interesting, and I want to discuss that for a moment before we go on. How are you given the definition of culpable negligence? We define simple negligence. Culpable negligence is, you can have negligence, but it can become more based on the facts and circumstances. It's important. The definition of culpable negligence is started by giving you the definition of simple negligence. The defendant cannot be guilty of aggravated manslaughter by causing the death merely from a negligent act. But culpable negligence is more than the failure to use ordinary care. In order for the negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing a reckless disregard for human life or the safety of persons exposed to its dangerous effects. See, that course of conduct is one way. Or safety of persons exposed to its dangerous effects. Safety of persons exposed to being left in a hot vehicle. It fits there. It fits there. Or shows wantonness or recklessness. Or grossly careless disregard for the safety and the welfare of the public, or indifference to the rights of others. The negligent act or omission must have been committed with utter disregard for safety of others. That's what we're talking about here. Those are the types of things that we're talking about. So when we start to talk about culpable negligence and what it is, that definition, I think, sets the stage of how you're to analyze. First, was there negligence? Second, was that culpable negligence? Follow that definition. So how do we determine what culpable negligence is? We just don't look at the act. We look at everything surrounding that act and the results of that act. That's what gives you culpability. That's what gives you criminal negligence. So in order to discuss that and have a conversation about that, I think we just need to go through briefly a rough timeline. We don't have anything set in stone, but we have good witnesses who testified, and we have an idea of exactly what happened that day. Around 9:30 to 11 a.m., there was some testimony, it might have been 10. Regardless, there was that permit. We heard from the two nice night ladies, Judy Terrell, the defendant herself. That's where she started out that day. Sometime between 11 and 12, she agreed to pick, she being the defendant, agreed to pick up Uriel that day. We know that she talked with Taylor. She at least messaged, and we do see on her phone around 11:18 that there was a conversation. Sometime between, and at that meeting is when they have from the prayer meeting from 9:30 to 11, lunch is discussed. We're going to meet at these. The agreement to pick up Uriel, I pick her up first. That's Gail goes along with her. Sometime between 12 and 12:30, we know from the time stamp at beef, she got there around 12:30. Between 12 and 12:30, she picks up Uriel. When she goes and gets Uriel, she gets a diaper bag with the supplies. She gets everything she needs to provide the care a responsible caregiver would give to that child. She picks that up. She also picks up a car seat and places it in her back seat. Once again, a responsible caregiver. She's provided all of these tools to do what she needs to do. So she gets that car seat, places it in the back seat of her car. 12:30 to 1:45 is roughly about the time the dart beeps. You saw the video, a portion of it. It's all there for you to review when you go back there if you choose to. We know around, it's that 1:45-ish area that she left, because one, we know from all the three ladies that were with her, Gail had to be out of there. And they know. They looked at their watch, and it was 1:40 when they started leaving. And we see on the Beef's video, which there's a timestamp on there too, that shows around the 1:43 they come out of the building. So we know she left around 1:45 with Uriel. And then she tells us in her statement she went straight home. No stops. And we know she's only about 3 miles away. About 8 minutes, 9 minutes, 10 minutes. So roughly 1:55, she gets home, gets out of her car, and leaves Uriel. The next thing we have is that 911 call. And we know that she made that 911 call at 12:05 p.m. We know it's after Rebecca made her call. So it's around that 5 o'clock hour that it's finally discovered that Uriel's in her car. 1:55 arrives home, exits the vehicle. We're going to say around 4:50, somewhere in there. 911 is called. That whole time in between, Uriel's left alone and forgotten in that vehicle. I do want to pause for a minute, speaking of the aggravated manslaughter, to address one other thing, the second count in this case. If you'll bear with me, we'll come back and we're going to talk a lot more about culpable negligence. But I think after seeing this, we're looking at almost 3 hours. It would be appropriate to discuss leaving a child unattended or unsupervised in the motor vehicle causing great bodily harm. What the judge is going to tell you, I have to prove to you that Tracey Howard Nix was a person responsible for Uriel. Uriel was younger than 6 years of age. Tracey Howard Nix left Uriel unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes, or for any period of time if the health of that child was in danger. Members of the jury, when she shut that door and walked away, that child's health was in danger from that point. But there is no doubt that more than 15 minutes elapsed. And in doing so, Tracey Howard Nix caused great bodily harm to Uriel. What greater bodily harm is there than death? That's all the time I'm going to spend on that count. I believe that count, it's unequivocal. It's there. So let's focus more on her actions. Let's talk about culpable negligence. Let's talk about wanton and reckless. We have to look at those circumstances surrounding. It's easy to say, oh, she just forgot. That's simple negligence. Well, That's the only way. If she did it on purpose, she'd be charged with murder. We charged her with culpable negligence. So yes, forgetting something is simple negligence. Forgetting to lock your door when you leave your house, simple negligence. Forgetting to take the food out of the stove, simple negligence. Maybe even forgetting that you were the parent that was supposed to pick up the child who's safe at school, but has to wait another 10 or 15 minutes because you forgot. Simple negligence. Leaving a child unattended in a car for 3 hours in the hot Florida sun baking. That's not simple. No matter how you slice it, that is not simple. Uri's death was not simple. Let's talk about that. We have to look at those facts and circumstances. It's not just the forgetting, but we have to look at what her duty was that day. She was the sole person responsible for the most vulnerable thing we have in our society as human beings. A baby. A baby. You have a heightened duty. You're in charge of something that literally can't live without you. She can't open that car door. She can't even get herself out of that car seat. She can do nothing to protect herself. She relies on someone to do it for her. She relies on a responsible person who keeps her first in her mind, who knows her duty, who knows this is a great responsibility. And we know that she knew that, and we'll talk about that in a minute, because she did that earlier. But she just got back to the house. I'm home. Let me do what I need to do. Uri deserved to be the primary focus in her mind that day. But she wasn't. And that goes towards the culpability. That goes towards the criminality of her negligence. That's why this happened. You have, when she is in your possession, she is your focus. She should be the first thing on your mind. Now, let's continue our discussion about the facts. She picked up Uri. Now, I know it was something that she wasn't expecting to do, but she did. She picked her up. She went and she got the diaper bag, she got the car seat, she got these, as I said earlier, were the supplies to ensure this child's safety. Members of the jury, the diaper bag was entered into evidence. And all those supplies are still in here. And you could feel the weight almost as much as Uri herself. She had everything she needed to protect her, to care for her, to ensure her survival. She had a car seat. She had everything she needed. She's the one who put it in there. At this point, Uri should be the only thing on her mind. Uri should be the primary focus on her mind. Again, the diaper bag. We can see the supplies, the bottles to feed her, the clothes to clothe her, the medications to give her. You can just see the volume of stuff that she had. Again, why do I show you all these things? These are the things that should push Uri to the forefront, that should make her the priority. The car seat placed in her vehicle. She's there. She's there. And what did she do when she went there? She didn't just immediately go home and say, oh, I forgot I had her. She went to lunch for an hour. Let's talk about that. The time it leaves. She's over there. She's there for over 1 hour. She comes to the restaurant. She didn't leave Uri in the car then. Uri's with her. She brought in the diaper bag. And as a matter of fact, you see constant attention's on Uri. As a matter of fact, Uri was not only the center of attention for the defendant, she was the center of attention for everybody there. There's something innate in human beings. When you see an infant like that, there's just a need to protect, a need to pay attention. And you could see that in the people around her. You could see that in the defendant herself. So why is this important? As I stated earlier, there she is. On her lap. The focus of her attention. Oh, she almost pushed off the bottle. Again, this is the thing that should be reinforcing in this caregiver mind, in this caregiver's mind, this is something I need to protect. This is something I need to look out for. Then she left these. She took Uri with her, didn't leave her in the restaurant, took her with her. Put her in the car seat. You can see the blanket over her shoulder. She brought everything out, didn't leave anything behind there. Put the diaper back. And then what'd she do? Drove straight home. And we saw her when she was leaving these. There she is. Diaper bag, white blanket, baby in hand, even the food. Didn't leave the food behind, had a friend bring it. There it is. Being placed right in the vehicle, Uri in the car seat. She knows she has Uri. She knew it. She placed her in that car seat herself. That's right behind her driver's seat. She's driving an SUV, but it's not one of those giant SUVs. It's not a Hummer. It's a small vehicle. She put the diaper bag in there. She put the blanket in there. All these things. And then where'd she go?
Was it just you and Uriel on the floor? Okay. And about, no, when you got back to the house, did you make any stops in between?
No stops in between, straight home. Straight home from spending an hour at lunch, phoning over little Uri. Didn't make any stops, no interruptions in between. Straight home. And what did she do when she got home? Well, parked her car, got out of her car, closed the door, and went about her business. What kinds of things would she do?
Okay. And I played my piano. And I practiced for a long time. I can't believe I didn't even think of. So you went straight home and you started talking to your dog? Yes. Okay. And what's your dog's name again? Macy.
So what is she doing? She goes home, gets out of the vehicle, got to go talk to the dog. Got to go practice my piano. I'm working hard at it. As I said, got out of the car. Meanwhile, Uri's left in that vehicle on a hot Florida 90-degree day. 3 hours. What is she doing in that 3 hours?
And when you went inside after getting home, what did you do? I went and started watching the piano. I think lessons that I have one on Thursday, and I need to just put in time on it. Okay.
She's practicing her piano, and Uri's body is fighting the heat.
I was thinking my other grandson was supposed to take it out for dinner. Okay. And I was impatient because they were about an hour behind. And I finally got in the car and went down to the barn because they had to go keep the pig, 4-H pig. And all of a sudden, when I got out of the car, it came across my head that I had Uriel and what happened. And came to pick her up and couldn't remember what happened.
She was more focused on her meeting that she had planned with her grandson than the 7-month-old whose body was fighting the heat in the car while she was thinking about all this stuff. Didn't even dawn on her.
Now, just so I understand correctly, Ms. Tracey, you said that you were going to get your other grandson for dinner. Okay. That has been planned for several days.
Again, that's the thing that is more important to her at the time that she's thinking about. Getting out, taking care of the dog, playing the piano for an hour. Plans that she had made the day before, ignoring the plan that she had made that day and that obligation that she made that day. to protect that child.
After 4:30, got in the car so that I would be there when they were feeding the pigs, which is done.
She actually got back into the car to go feed the pigs. Got back into the car where Uri, at 4:30, where Yuri's been now for 2.5 hours on her own. Still, nothing.
About how long after 4:30 did you realize that she was in the car?
I sat and talked today, probably 5 to 10 minutes, with him sitting on the mower and me sitting in the car. And then I got out because Rebecca Aiden had come up, and I was going to see if I could help him. And all of a sudden, I realized I just had that flash of what had happened to Uriel. And then all of a sudden, I realized he was open the door.
She's in the vehicle with Uri, if we're believing her story, for 10 to 15 minutes. And still, Yuri's not at the top of her mind. It's not her primary focal point. Members of the jury, I think we've hit upon all of those things. When you look at all of those actions and inactions and choices that she made that day, it fits. It fits the definition of criminal negligence. It fits it. Again, you have to look at everything, not just the forgetting, but everything that went along with it. She shouldn't be forgetting. She has every reason to remember. It's 7 months old and it's in the back seat. That's the reason to remember. This isn't like, again, she says during her statement, I wasn't expecting it. Fair. That's fair. You weren't expecting it. But she didn't drive immediately home. She spent an hour with Uriel. She spent an hour with her. But the fact of the matter is, when she got home, I'm home, got to take care of my stuff. At that point, a 7-month-old is completely helpless. A 7-month-old deserves to be the center of your attention. A 7-month-old deserves to be taken out of that car and into the house. Members of the jury, when you're back there discussing what culpable negligence is, I would suggest that you look to the evidence, because the evidence is there. It's Yuri's little hand frozen in a fist because of rigor mortis. It's Uri lying on a table at the hospital when she should be sitting in the house of the grandmother. That is culpable negligence. Right there for all of us to see. Unfortunately, as I said earlier, Uri deserved someone who was making her first. And instead, what she got was neglect. Not just neglect, but criminal neglect. She didn't deserve to be forgotten. She didn't deserve to be trapped. She didn't deserve to die. What she deserves is the person who is responsible for that criminal act to be held accountable for what she did. And that's what I'm asking you, the jury, to do, is hold Tracey Nix responsible for failing Uri. Hold her responsible for that culpable negligence of not paying attention to, of leaving her trapped and alone. Find her guilty as charged. Thank you.
Thank you, Mr. Coleman. Mr. Fletcher, for that.
Thank you. Hey, police court, Mr. Coleman. Good morning, ladies and gentlemen. Sorry I don't have a slideshow to present you. Basically, the state's evidence is the defense evidence. The truth is the truth. The facts are the facts. We haven't tried to hide anything here. We tried to present the truth to you. I think every detective said that Tracey Nix and family were all honest with you. Tracey Nix is innocent of these charges, ladies and gentlemen. And I ask you, please do not convict her because of your emotions over the fact that this is a child. Now, I'm not going to get into it right now, but the state has misstated some things regarding culpable negligence. I chose not to object, but I will go over that with you. I can't imagine losing a child, what that does to you. When my daughter was a child, that was my biggest fear when she was growing up. She's now got children. I also fear loss of a grandchild. It hurts. It's horrific either way. This whole thing is a tragedy, ladies and gentlemen. Don't compound this tragedy by convicting of her of something she's not guilty of. This is what the state's proven to you. They presented 15 or 16 witnesses. They presented at least 3 videos. I may have miscounted there. They showed you that Tracey Nix was a school teacher for almost 40 years. Tracey Nix was a churchgoer for almost 40 years. Sang in the choir, taught Sunday school, even had retreats for children, obviously loved children, even wrote the curriculum for these retreats, these weekend retreats. She's also a loving, caring, devoted grandmother. Grandmother, ladies and gentlemen. Loved her grandkids too. Tried to help her daughter out with Uri. Kept Uri a lot. Did whatever she could for Uri and for her daughter, Kayla. And she also cared about her other grandkids. On this particular day, she was supposed to go with her daughter Rebecca's grandson out to eat and to go Christmas shopping. So that's what we have. That's who we're dealing with. A good person, a good lady, a good grandmother. You saw 3 videos. Now I'm kind of amazed here that the state shows the video from Beef O'Brady's as evidence of guilt. And I invite you to look at that video again when you get back in the jury room, because you'll have that opportunity, and just look and see what an attentive, caring, loving grandmother this lady is, still is, and how she treated Uri. It's not something we made up. This is the video before all these events. But look for yourself and see. And don't let the state confuse you by adding these things, apples and oranges, as far as the element of culpable negligence, which is the crux of the issue in this case. Then they had 2 other videos that they showed Tracey Nix right after the incident, when she became aware of what had happened, how devastated she was. Completely, obviously loved this child, loved this baby. And then down at the sheriff's office, and even though Detective Fletcher said, well, I'm not sure I told her that she was being recorded or not. Obviously, she didn't know that. You can see her reaction and how much it affected her and how much she loved this child. So, ladies and gentlemen, Tracey Nix is guilty of simple negligence, and we don't deny that, but not criminal negligence. And you don't really hear about people being criminally charged for simple negligence. Give you an example. You run off the road a little bit, maybe there's a hole there, whatever, 3 or 4 people die. You hear about traffic accidents, 5 or 6 people get killed. Simple negligence, nobody's charged. This happens all the time. Now, we discussed a little bit on opening statement about, you hear people, parents or whoever, leaving babies in the car seat. You don't know what the ultimate disposition is. You hear, well, they got arrested. depends on the facts whether you're guilty. You've got to have culpable negligence, ladies and gentlemen. These criminal jury instructions, the state looked at them and I'm going to suggest, they misinterpreted, and they've added, they've confused these three elements. There's three elements. There's no doubt that the child has passed away. Count 2, the death was caused by culpable negligence. And then count 3, the child was, Uriel was a child and her death was caused by the neglect of Tracey Nix. And that's where he's confusing 2 and 3 and trying to sell this to you. Culpable negligence. Please listen carefully, and I can't stress this enough. Every person has a duty to act reasonably toward others. And this is what the judge is going to read to you. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. That's what we have. Read it again. Every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Conscious. Where have they shown you anywhere that Tracey Nix consciously did this? Now, this is culpable negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. She forgot. That's the act. That's not culpable negligence. Forgetting. It's more than a failure to use ordinary care toward others. In order for it to be culpable, it must be gross and flagrant. Again, separate the act from what actually the result was. You have to separate the two. It's got to be gross and flagrant. She forgot. She simply forgot. Grandma forgot. Culpable negligence is a course of conduct showing reckless disregard of human life. Do you think she intentionally left this child in this car? Can you possibly, after seeing those videos, even think for a second that she intentionally and recklessly left this kid in this car? She forgot. Simple negligence, ladies and gentlemen. Now, I'm just reading the jury instruction. Culpable negligence is a reckless disregard of human life or the safety of persons exposed to its dangerous effects, or an entire want of care as to raise a presumption of conscious indifference to the consequences. Do you think for a second that she had a conscious indifference to the consequences? Again, she forgot. The results are horrendous. That's a separate element. They have to prove culpable negligence, and they can't do it. They can put on diaper bags. They can put on this timeline. They can put on this video from Beef O'Brady's, but none of that shows culpable negligence. This is extremely high burden of proof that they have to prove beyond a reasonable doubt. Continuing. Wantonness or recklessness, grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of rights. Did they come anywhere close to showing any type of intentional violation of rights? It has to be tantamount or equivalent to an intentional violation of rights. Culpable negligence is consciously, and again, I'm continuing reading the jury instruction. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. This is replete with gross, flagrant, conscious disregard. There's nothing here to show that. They've shown simple negligence. Again, every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Again, that's what we have. These are very serious charges. I ask you to deliberate, read these instructions at 7.7a, and look at the definition of culpable negligence. They have not proven it. The whole issue here, again, is culpable negligence, and she forgot when she got home. And you say, well, why did she forget? I don't know. The brain's a strange thing. Why did she forget? Was it age? Distractions? They had the roofers there that day. You had other plans. But again, she simply forgot. She simply forgot. And when she remembered, well, you saw what happened when she remembered. You know, Tracey Nix has to live with this forever too, carry that burden for what happened that day. But again, it was simple negligence. When you forget, you forget. And when you remember, why do you remember again? Now, I'm sure every one of you, regardless of your age, has had an incident or a number of incidents where you're supposed to pick up something or somebody on the way to work. You get to work. You're supposed to pick up something at the grocery store on the way home. You forget. It's simple negligence. It was simple negligence here. The state was wrong when they said that there's a higher duty when it's a child. That's number 3. That's not number 2. There's nothing in culpable negligence that talks about babies as opposed to anybody else. You have to look at that. The actions of Mrs. Nix. The actions, not the results. There's nothing we can do to bring this child back, ladies and gentlemen. And again, I urge you to look at the definition. Again, he's taking simple facts. He's turning that into culpable negligence. And please don't make this terrible situation worse by convicting Tracey Nix of something that she's not guilty of. Thank you.
Thank you, Professor State.
I started out when I spoke with you folks, discussing mistakes, and sometimes sorry isn't enough. And I would argue that the judge is going to instruct you on something that agrees with me. The court's going to instruct you that this case must not be decided because you're for or against it, because you feel sorry for anyone or angry with anyone. And I agree with that. No matter which side, we're human beings. I apologize to you, the jury, because we asked you to do something impossible, which is set aside what makes you human, your emotions, but you have to do it. And I stress, and I would agree, and I would echo, look at those facts. Those facts reveal the truth. Those facts reveal the crime. Don't make that decision because you sympathize with her. Don't make that decision because you're angry at her. Make that decision because she did it. That's what you need to make your decision on. I do want to spend a few moments of my time addressing some of the things that the defense said. Uri, she isn't milk. She isn't groceries. She isn't an unlocked door. She isn't the pet you forgot to walk. She was a 7-month-old baby. And yes, you have to consider that when you consider whether something's reckless. What would a reasonable person who's in charge of a 7-month-old, who is responsible for her life, her survival, what would they do
in that situation. The defense wants you to take the simple act of forgetting and focus on that and say, you can't look at the results. You can't look at the other factors. No, members of the jury, you have to. That is what tells you whether a simple mistake, simple negligence is reckless and wanton. And I would argue to you, members of the jury, that it is here today. She should not have forgotten about that child. She spent all that time with that child. Defense points out, well, I can't believe we showed you the video. Yeah, we showed you the video because that Tracey Nix that was at Pico Brady's should have been the Tracey Nix that got out of the car, but it wasn't. She was more focused on other stuff she wanted to do when she got home that she completely forgot about her. Not for 15 minutes, not for a half hour, not for 45 minutes, not for an hour, not for 90 minutes, not for 120 minutes, for almost 3 hours. Is that something a reasonable caregiver would do? Or is that something that's gross and flagrant and wanton and reckless? The act of leaving the child in the car, I don't think anyone would argue. If she, again, like I said, if she intended to leave that kid in that car and Uri was trapped in there, she would be charged with a very different crime. We're talking about, it can be confusing, we're talking about negligence. She doesn't have to have the intent to hurt Uri, but her actions did anyway. That's what we have to look at. It's a difficult case, members. It's a difficult crime. It's a difficult law. It is, but the facts are there. And once again, I need to remind you, she is not stepping on someone's foot. She is not leaving your eggs in the car overnight. She is a child. Defense counsel keyed in on a word, and there is a word in the culpable negligence instruction, conscious, and that throws people off. Conscious as opposed to unconscious. That's what that is. She was conscious the entire time. She should have known. She should not have forgotten. She had no reason to forget other than there were things more important, like playing the piano, taking care of the dog, feeding the pigs, finding her husband, those types of things. And defense counsel wants to talk about distractions. Well, from what we saw at Pico Brady's, she deals well with distractions. There were a lot of distractions around her. Everyone came up to see that. But she didn't forget Uri then. She didn't forget that. She took care of her. She did everything she was supposed to do. Unfortunately, Beef O'Brady's Tracey Nix stayed there. What came home was the one who committed criminal negligence. At the end of the day, members of the jury, I think you have to look at all the facts and circumstances, not just the forgetting, but all of the surrounding circumstances. And you have to look at that and say, what would a reasonable person in that situation do? What would a reasonable person who is responsible for the care and safety of a 7-month-old infant do? And I would argue to you, it would be, remember, don't forget, don't leave, be focused on her. Make sure she's okay. She's your little granddaughter. Care for her, protect her, get her out of the car. And a failure to do that, members of the jury, that's a mistake, that's criminal. That's a mistake, that's culpable. That's a mistake, that's the crime of aggravated manslaughter. That's the mistake that she needs to be held accountable for under the law. And you need to go back in that jury room and convict her. Thank you.
Thank you. Do you want to close your screen down?
Yes, sir.
Please. All right, members of the jury, I want to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. We're going to hand you each a copy of the instructions. Please go ahead and do that. Now, clerk, move it. You'll be able to take these instructions to the jury room with you. You'll have a verdict form. You'll also have information with the appropriate information. Statement of the charge. Tracey Howard Nix, the defendant in this case, has been accused of aggravated manslaughter of a child and leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm. You'll have an information that shows the charges and the statutes. I won't read it to you because y'all all can read it when you get back there. That's fine right now. We'll be fine with just what we have now. Aggravated manslaughter in Florida is to prove the crime of aggravated manslaughter. The state must prove the following three elements beyond a reasonable doubt. Uriel Jane Schock is dead. The death of Uriel Jane Schock was caused by the culpable negligence of Tracey Howard Nix. Uriel Jane Schock was at the time a child, and Uriel Jane Schock's death was caused by the neglect of Tracey Howard Nix, a caregiver for Uriel Jane Schock. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life and of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The defendant cannot be guilty of aggravated manslaughter if the killing was either justifiable or excusable homicide. I'm not going to instruct on that because we do not have that here. I'm going to tell you to exclude that off of these instructions. Child means any person under the age of 18 years. Caregiver means a parent, adult household member, or any other person responsible for a child's welfare. Neglect of a child means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain a child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical or psychological or mental injury or a substantial risk of death to the child. Leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following four elements beyond a reasonable doubt. Number one, Tracey Nix was a person responsible for Uriel Jane Schock. Number two, Uriel Jane Schock was younger than 6 years of age. Number three, Tracey Howard Nix left Uriel Jane Schock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. 4, in doing so, Tracey Howard Nix caused great bodily harm to Uriel Jane Schock. Motor vehicle means a self-propelled vehicle not operated upon rails or guideway, but not a bicycle, electric bicycle, motorized scooter, electric personal assisted mobility device, mobile carrier, personal device, swamp buggy, or moped. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. When there are lesser included crimes or attempt, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of a lesser included crime. The lesser included crimes indicated in the definition of aggravated manslaughter of a child is manslaughter. The lesser crimes included in the definition of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm is leaving a child in a motor vehicle in excess of 15 minutes. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number one, Uriel Jane Schock is dead. And number two, the death of Uriel Jane Schock was caused by the culpable negligence of Tracey Howard Nix. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violence is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Leaving a child unattended or unsupervised in a motor vehicle. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following four elements beyond a reasonable doubt. Number one, Tracey Howard Nix was a person responsible for Uriel Jane Schock. Number two, Uriel Jane Schock was a child younger than 6 years of age. And number three, Tracey Howard Nix left Uriel Jane Schock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. Motor vehicle means a self-propelled vehicle not operated upon rails or driveway. Vehicle means every device in, upon, or which by any person or property is or may be transported or drawn upon a highway. If not guilty, reasonable doubt and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Throughout your deliberations, you may discuss with each other the evidence and the law that has been presented in the case, but you must not communicate with anyone else by any means about the case. You also cannot learn from outside sources about the case, the matters in the case, the legal issues in the case, or individuals or other entities involved in the case. This means that you may not use any electronic devices or social media such as a phone, computer, or tablet, the internet, any text or instant messaging, or any social media apps such as Twitter, Facebook, Instagram, LinkedIn, YouTube, WhatsApp, and Snapchat to research or communicate about what you've seen and heard in this courtroom. These restrictions continue during deliberations because it's essential under our Constitution that you decide the case based solely on the evidence and law presented in this courtroom. Information that you find on the internet or through social media might be incomplete, misleading, or inaccurate. And as I noted in my instructions at the start of the trial, even using your smartphone, tablets, and computers and news media and social media apps on those devices may inadvertently expose you to certain notices, such as pop-ups or advertisements that could influence your consideration of the matters you've heard about in this courtroom. You are permitted to discuss the case only with your fellow jurors during deliberations because they have seen and heard the same evidence and instructions on the law that you have. And it is important that you decide the case solely on the evidence presented during the trial without undue influence by anything or anyone outside the courtroom. For this reason, I expect you to inform me at the earliest opportunity should you learn about or share any information about this case outside of the courtroom or the jury room, or learn that another juror has done so. You will weigh the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed with law enforcement does not mean that his or her testimony should be given any other weight than any other testimony. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant did not testify in this matter. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. The defendant's statements were introduced into evidence. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should always be considered with caution and be weighed with great care to make sure it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether this defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to, 1, whether when the defendant made the statement, they have been threatened to get them to make the statement. 2, whether anyone had promised the defendant anything to get the defendant to make the statement. If you conclude the defendant's made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply for your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. I've read them to you. You're going to get them, take them in the back. If you fail to follow the law, the verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have learned that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job, my job, to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions that I'm giving you and that I've read to you. That is the law. I'm going to caution y'all. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. When you reach a verdict, you may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It's 2 pages. The first page is the count 1 and 2, and the second page is where the foreperson dates and signs it. It says, in the Circuit Court, 10th Judicial Circuit of Florida, NN4, Hardy County, State of Florida versus Tracey Howard Nix, CF 22-289A, verdict form. We, the jury, find as follows as to count 1 of the charge. Check only 1. You check 1. The defendant, Tracey Howard Nix, is guilty of aggravated manslaughter of a child, or the defendant, Tracey Howard Nix, is guilty of manslaughter, a lesser included offense of count 1, or this defendant, Tracey Howard Nix, is not guilty. You go then to count 2. We, the jury, find as follows as to the count 2 of the charge. Check only 1. The defendant, Tracey Howard Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes, causing great bodily harm, or the defendant, Tracey Howard Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes, a lesser included offense of category 1, or the defendant, Tracey Howard Nix, is not guilty. You go to the second page, you date it, the foreperson. So we all say this blank day of January 2025, foreperson signs it, prints the name. A single defendant with multiple counts or information. A separate crime is charged in each count of the information, and although they have been tried together, each crime and evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. I'm going to submit the case to you as the jurors. We're going to have lunch. It's already been ordered for you. It'll be in there. You're going to have time. So in a few minutes, the bailiff's going to take you to that room. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside the jury about this case until you have reached a verdict. You must talk about this case in person or through the telephone, writing, electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given you in the case, you must tell me by giving a note to the bailiff. Many of you have cell phones, laptops, tablets, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the courtroom. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do take your notes. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. We do have a machine for y'all to go through whatever you want or don't want to see. It's going to be there. Y'all choose what you're going to see. This is your deliberation. These exhibits will be sent to the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. All right, let me speak to the lawyers for a minute on the record, and then I'm going to retire the jury. There's 2 people that are alternates, and since we're going to be going into deliberations, we no longer need the alternates. So I have jurors 1, 2, 3, 4, 5, and 6. The alternates are 7 and 8, and the chairs that are sitting there. And you will be released. We'll allow you to go in and get your items, and the bailiff will escort you to it. You're welcome to come back into the courtroom and wait on the verdict. You're welcome to go home, do anything you'd like. Obviously, it's your choice. The trial has been live streamed, so that's your choice, what you do. All right? We talk with the state and the county.
So, just a reminder, well, we might as well go live straight away. As soon as the jury, well, now, basically, we're going to head over to the other trial and start that. This finished a lot earlier than I thought. Hang on, where is it? I'll change that timing on it. And then we'll be done. We'll be going over. I put it in to start at 11:30. Oops, wrong time. 30. Save changes. So yeah, hang on. What's he gonna say now? Hello, Wendy. Thank you, Wendy, for the coffees yesterday. I'm not sure if you were here when I said thank you. So once they sent them away, we are going to go and watch the Natalie Cochran trial. She is accused of killing her husband through poison. So that's the one we're going to watch. That's from West Virginia, where Rebecca's from. So I was going to start it at 1 o'clock, but might as well start it straight away. That started today, so it should be an interesting one. Yeah, Cornpole, the daughter is very 50-50 about it all. She wants justice for the children. But she also loves her mother. Lady died, knows what to get. Yeah, show the jury again. Dude.
All right, members of the jury, we're gonna take the jury instructions back from you. We have to switch out a page that I read correctly that was not in there. So we'll give you the corrected jury instructions and the corrected verdict form. Is that correct?
Yes, sir.
And you'll be getting them in the back. So what I'd like to do now is we're gonna release the alternates. I've identified who they are. I'd like the jurors to go all back into the jury room, get all your personal belongings alternates, come out in the bailiff will escort you where you need to be. Don't discuss anything with each other until the alternates have left. Does everybody understand that? I have one question of the jurors before I let you go back. We've talked about, have you seen or heard anything outside this courtroom through the witnesses and the evidence that you shouldn't see? Media, papers, telephone calls, or other information. By show of hands, has anyone received any information since I asked this morning or yesterday that causes you to not be a fair and impartial juror? If you do have, raise your hand, please. I see no hands raised, so y'all have adhered to my rules and you've not seen any outside media sources. All right, thank you all for your patience. All rise, we're sending the jury out at 11:25 on the record.
Mary, I'm not sure, Mary. Yeah, I don't know, Mary, if I'm being honest.
So I'll have a seat. We're going to take a minute or something. Then we'll start. I need to make sure the state and the defense get everything put together.
Okay, well, that's the end of that because that is everything that we need to know. Mary is this one, Mary Wyro. So, right, quite good timing that is. So I'm going to have that up still, and we will do a verdict watch. But I'm going to close this now. You should be redirected to the new one, new trial, and we will be watching that one. So, with that, love you all as always, and I am going to kick you all over, so that we can start the new trial. Right, ladies and gentlemen, I'll see you in a minute. Love you. See you in a bit. Ta.